wants $75 million and could well bankrupt Prince Harry.
In my personal opinion, it's because this confused and angry, spoilt brat can never admit he was wrong.
He has had another tantrum. He has lost his ever-loving mind. He cannot deal with the no, and he's losing it. He's completely lost it, okay?
https://www.youtube.com/watch?v=HTHOTA3HMSM. 75 million pounds. Read that number again and let it marinate in your mind, because Prince Harry certainly is. And word on the street is he's having the absolute mother of all royal meltdowns. Imagine walking out of the highest court in the land after losing not one, not two, but 97 separate allegations, only to hand your sworn enemies the ultimate weapon. A single four-syllable word that could literally bankrupt your entire future. Whitewash. That's right, folks. The Duke of Sussex didn't just take the colossal loss on the chin and quietly fly back to his Montecito mansion. Oh no, he went live, looked the entire British judicial system in the eye, and basically accused a high court judge of running an institutional cover-up. And now, the Daily Mail isn't just asking for their standard legal fees back. They are going straight for the jugular, insisting on an eye-watering $75 million bill that could wipe out his fortune in one fell swoop. Is this the ultimate financial reckoning for a prince who thought the rules of gravity didn't apply to him? Did Harry's fiery post-trial tantrum just destroy his own legal insurance and force King Charles into an impossible corner? Or is the British press pulling off the most expensive revenge plot in royal history? Grab your popcorn, because today we are breaking down the total chaos, the collapsing evidence, and the massive multi-million-pound nightmare that currently has Harry completely erupting. The dust hasn't even settled inside London's High Court, and the sheer scale of this absolute catastrophe is sending shockwaves from the historic halls of Westminster all the way to the sunny hills of California. To truly understand why the Daily Mail's parent company, Associated Newspapers, is currently circling Prince Harry like a pack of bloodthirsty legal sharks, we have to go back to how this epic disaster actually started. For years, Harry has built his entire post-royal brand around a single uncompromising narrative: that he is the crusading prince, the courageous whistleblower single-handedly taking down the ruthless UK tabloid empire to avenge his late mother and protect his family. He walked into that courtroom carrying the weight of what he claimed was an ironclad case against the press, alleging widespread, systematic unlawful information gathering, phone hacking, illegal wiretapping, and private investigators breaking into every corner of his private life. Joining him in this high-stakes crusade were a star-studded lineup of co-claimants including Sir Elton John, Elizabeth Hurley, Sadie Frost, and Baroness Doreen Lawrence. On paper, it was framed as the ultimate David versus Goliath battle. The prince was standing up for the victims of media intrusion, ready to expose the deep, dark underbelly of Fleet Street once and for all. But when the dust cleared after 11 agonizing weeks of trial and years of multi-million-dollar legal preparation, the reality that crashed down upon the Duke of Sussex was not a glorious victory, but a total unmitigated institutional annihilation. Mr. Justice Nicklin, the formidable High Court judge presiding over the case, handed down a devastating 436-page judgment that didn't just reject Harry's claims, it completely demolished them. Out of all 97 individual allegations brought forward by Harry and his legal team, how many do you think stood up to judicial scrutiny? 0. Not 90, not 50, not even one solitary claim survived. The judge painstakingly dissected every single piece of testimony, every supposed piece of evidence, and every dramatic accusation, coming to a conclusion that was as cold as it was brutal. The court found that Harry's case was built almost entirely on wild suspicion, emotional assumptions, and deep-seated grudges rather than actual hard legal proof. The narrative that the prince had spent years carefully crafting in the court of public opinion completely disintegrated the moment it was forced to face the harsh light of actual cross-examination inside a real courtroom. To make matters infinitely worse, the foundation of Harry's entire argument suffered a catastrophic internal collapse during the trial itself. A key witness, a private investigator whose supposed confessions were treated by Harry's legal team as the smoking gun that would bring down the Daily Mail, effectively recanted and disowned his central statements the second he entered the witness box. Imagine spending tens of millions of dollars, rallying your famous billionaire friends, and hyping up the trial of the century, only for your absolute star witness to crumble under pressure and undercut your entire case from the inside. It wasn't just a minor legal hiccup. It was a total structural collapse of a multi-million-pound lawsuit. Yet, instead of reading the room, quietly accepting the embarrassing defeat, and letting his high-priced legal team handle the fallout behind closed doors, Harry did what Harry does best. He completely lost his composure, reacted with explosive anger, and released a joint statement alongside Doreen Lawrence that sent immediate shockwaves through the entire British establishment. In that infamous statement, Harry didn't just express disappointment with the verdict. He took a metaphorical sledgehammer to the judicial system itself. He openly described the High Court judge's carefully calculated decision as a complete and obvious whitewash, claiming that the judicial system had gone to shocking and totally unwarranted lengths to protect and clear the Daily Mail's name. Let that settle in for a moment. A former senior working royal, a man whose own father is the reigning monarch and head of state in whose name those very courts operate, publicly stood up and accused a sitting High Court judge of orchestrating a corrupt cover-up for a media outlet. It was a moment of unhinged emotional defiance that instantly turned a massive legal defeat into an unprecedented constitutional scandal. The immediate reaction from the legal and political elite in the United Kingdom was swift, brutal, and completely unforgiving. Two former Justice Secretaries publicly came out to lambaste the prince, calling his aggressive comments over the top, deeply personal, unacceptable, and a reckless assault on the independence of the judiciary. High-ranking legal figures in the House of Lords openly condemned the Duke, pointing out the breathtaking irony that judges in Britain swear allegiance to the crown, meaning Harry was effectively accusing his own father's legal apparatus of fraud and corruption. Behind the palace gates at Buckingham Palace in Highgrove, the mood reportedly turned ice cold. King Charles was said to be deeply humiliated and incandescent with rage over his son's reckless outburst, recognizing that Harry had just dragged the constitutional authority of the monarchy directly into the mud of his personal vendetta against the press. And while the royal family recoiled in sheer embarrassment, over at the headquarters of Associated Newspapers, the executive suite was preparing to launch a legal counter-offensive of nuclear proportions. Paul Dacre, the formidable head of Associated Newspapers and the legendary former editor of the Daily Mail, wasn't just relieved by the judge's verdict. He was smelling total victory and ultimate blood. For years, the Daily Mail's journalists, editors, and executives had lived under the massive dark cloud of these terrifying allegations, facing relentless public attacks on their professional reputations, livelihoods, and journalistic integrity. Now that the judge had completely vindicated the publication and called out the claims for being hollow suspicions, the executives at the Mail were ready to unleash absolute mayhem on the prince who had tried to destroy them. Insiders close to the publisher quickly leaked that the company fully intends to go straight for the jugular in recovering every single penny spent on their defense. They aren't looking for a polite, quiet settlement or a minor slap on the wrist. Associated Newspapers revealed that their total legal costs incurred over this epic, multi-year saga have soared past a staggering £50 million, with total overall costs for both sides ballooning beyond $75 million. And with a crucial two-day costs hearing officially locked into the High Court calendar, the Daily Mail is coming to the table armed with Harry's own disastrous words. By branding the judge's ruling a whitewash, Harry didn't just blow off steam. He handed the Daily Mail's top-tier legal team the ultimate golden ticket to demand an extraordinary indemnity costs order. In simple, terrifying terms, an indemnity costs order is a rare legal hammer reserved specifically for litigants who display unreasonable, improper, or unhinged behavior during or after a trial. If granted, it effectively strips away standard cost protections, uncaps the bill, and forces the losing party to cover virtually every single penny of the winner's astronomical legal bills. Harry's four-syllable temper tantrum might have just turned a regular legal bill into an open-ended financial death sentence. The terrifying reality of an indemnity costs order is that it transforms a standard legal dispute into an absolute financial execution, and that is precisely where Prince Harry now finds himself trapped. To fully grasp the sheer magnitude of the financial trap closing in around the Duke of Sussex, you have to understand how high-stakes litigation in the High Court actually operates when things go completely off the rails. Normally, when someone loses a civil case in the United Kingdom, standard costs rules dictate that the losing party pays a reasonable, heavily negotiated, and capped percentage of the winner's legal expenses. Courts typically trim off the excess fat, capping the payout to ensure that legal fees don't completely ruin a litigant. But the moment Harry stood before the world's media and threw the word whitewash at Mr. Justice Nicklin, he shattered those standard protections into a million pieces. Legal experts across London, including former High Court cost judges who spend their entire careers calculating these exact figures, are pointing out that Associated Newspapers now has a virtually ironclad argument to demand full indemnity costs. An indemnity order means the court stops being sympathetic to the loser. Instead of capping the bill or meticulously debating every hourly rate charged by top-tier defense barristers, the court effectively hands the winning side a blank check, forcing the loser to reimburse nearly every single expense incurred throughout the grueling years of litigation. The Daily Mail's parent company claims it has already spent upwards of £50 million purely defending its journalists, its reputation, and its institutional existence against what the judge officially deemed as unsubstantiated suspicions. When you combine that astronomical figure with the legal fees racked up by Harry's own high-priced legal team, the grand total floating around this legal war effortlessly blows past $75 million. That is not just a heavy financial blow. That is the kind of catastrophic, wealth-destroying figure that forces people to liquidate major assets, sell off prime real estate, and completely rewrite their long-term financial survival plans. What makes this unraveling so utterly chaotic is the fact that Harry's safety nets are evaporating faster than water in the California desert. Before stepping foot into that courtroom, Harry's legal team relied on two primary financial shields designed to keep him safe from total ruin: cost-capping orders and after-the-event legal insurance. Under normal circumstances, court-mandated cost caps act as a ceiling, guaranteeing that even if a claimant loses badly, their financial exposure is limited to a pre-agreed maximum amount. However, lawyers for Associated Newspapers are currently preparing a ferocious motion for the upcoming two-day hearing to have those cost caps completely lifted and thrown in the trash. Their argument to the judge is as simple as it is lethal. Why should a wealthy prince be granted the privilege of judicial cost protection when he brought 97 completely unproven allegations, forced a 46-day trial, and then turned around to publicly accuse the presiding judge of running a corrupt whitewash? If Justice Nicklin agrees to lift those caps, the ceiling vanishes entirely, leaving Harry exposed to the full, unmitigated weight of a $75 million war chest. Then comes the insurance nightmare, which is sending shockwaves through Montecito right now. To cushion the blow of a potential loss, the claimants had secured after-the-event insurance, commonly known as ATE insurance, through a specialized firm called Temple Legal. On paper, this policy was supposed to act as the ultimate safety cushion, promising to cover up to $19 million in adverse legal costs if the court ruled against them. $19 million is already a drop in the ocean compared to the $75 million being demanded by the Mail, but now even that $19 million safety net is hanging by a razor-thin thread. Insurance policies of this magnitude are not blank checks handed out of charity. They come packed with strict, non-negotiable conduct clauses. If an insured party behaves in a way that recklessly increases their own liability, breaches duty of good faith, or actively undermines the legal process, the insurer has full legal standing to invoke exclusion clauses and completely void the policy. Insiders close to the case are quietly whispering that executives at Temple Legal are watching Harry's public outbursts with absolute horror. By publicly attacking the integrity of the High Court, calling the judgment unwarranted, and effectively declaring the British judicial system corrupt, Harry didn't just insult the judge. He gave his own insurance company the perfect, legally bulletproof excuse to walk away, cancel the policy, and refuse to pay a single penny. A source close to Harry's own camp reportedly let slip that issuing that furious post-verdict statement was very stupid and very unnecessary, recognizing too late that those 4 emotional words might have just cost the prince his multi-million-dollar insurance backup. If the insurer officially pulls out, the vast, multi-million-dollar gap between what Harry owes and what gets covered stops being a theoretical legal argument and instantly turns into a brutal, personal financial crisis that hits his personal bank account directly. And the clock is ticking down at a terrifying speed. The High Court doesn't wait around for defeated litigants to gather their thoughts or raise funds. Legal experts are widely forecasting that following the 2-day costs hearing scheduled for the end of July, Justice Nicklin will likely issue an immediate order for an interim payment on account. In plain English, an interim order is a mandatory down payment that must be paid almost immediately, while the final, exact total is meticulously calculated over the following months. That initial down payment alone is expected to be slapped at a mind-boggling $13 million, with a strict court deadline requiring full payment within 14 days of the decision. That means before the middle of August, Prince Harry could be legally required to hand over $13 million in cold, hard cash to his absolute bitterest media enemies. If a litigant fails or refuses to pay a court-ordered interim cost payment within the strict 14-day window, the legal system unleashes its most aggressive enforcement mechanisms. We are talking about formal bankruptcy proceedings, high-priority charging orders placed over personal properties, the freezing of international bank accounts, and severe insolvency measures that would strip away whatever remains of Harry's public dignity. While some of his wealthy co-claimants, like music legend Sir Elton John with his staggering $600+ million fortune, can easily write a check to cover their portion without blinking an eye, Harry's financial landscape is vastly different. His wealth, while substantial, is heavily tied up in complex commercial deals, production contracts, and high-maintenance personal lifestyle expenses that don't easily convert into tens of millions of dollars of instant cash flow. To make the optics even more humiliating for the Duke, reports indicate that while Elton John is stepping up to help shield less wealthy co-claimants like Doreen Lawrence from financial devastation, no such safety net is being offered to Harry. The prince is being left out in the cold, isolated on his own legal island, forced to answer for his own tactical blunders and emotional outbursts. The very newspaper he spent years demonizing as the source of all his misery is now sitting in the ultimate catbird seat, holding the legal authority to drain his fortune, seize his assets, and potentially drive him into formal insolvency. The hunter has truly become the hunted, and as the deadline approaches, the frantic search for a financial savior is leading straight to the gates of Buckingham Palace, with the looming specter of a $13 million interim payment due within days and a total legal bill threatening to blow past $75 million. All eyes have turned toward Buckingham Palace in a state of absolute, breathless anticipation. The central, agonizing question dominating headlines across the globe is whether King Charles III will quietly step in, open the royal coffers, and write the massive check needed to bail out his estranged younger son. On the surface, the instinct for a father, especially a monarch with vast personal reserves and sovereign wealth, to protect his child from total financial ruin and public insolvency seems almost natural. However, when you look at the constitutional nightmare Harry created with his post-trial tirade, any potential royal intervention transforms from a private family favor into a full-blown constitutional crisis that threatens the very core of the British monarchy. To understand the sheer impossibility of the position King Charles now finds himself in, you have to look at the foundational architecture of the British state. In the United Kingdom, judges do not rule in their own personal names, nor do they rule in the name of Parliament. Every single High Court judge, including Mr. Justice Nicklin, derives their legal authority directly from the Crown itself. They swear a sacred oath of allegiance to the reigning sovereign, acting as official representatives of the King's justice. Therefore, when Prince Harry stood before the world's cameras and declared that the High Court judgment was a complete and obvious whitewash, he was not simply insulting an individual judge in a traditional wig. Whether he fully grasped the gravity of his words or not, Harry was publicly accusing his own father's judicial authority of operating a corrupt, biased cover-up to protect a national tabloid newspaper. Imagine the breathtaking hypocrisy if King Charles were to quietly step in and use royal funds to pay off the astronomical fines and legal bills resulting directly from an attack on his own judiciary. If the king picks up the tab for Harry's whitewash tantrum, he is effectively using the wealth of the monarchy to underwrite an insult aimed directly at the British legal system. Legal scholars, constitutional experts, and politicians across the spectrum have pointed out that such a move would send a catastrophic message to the public. It would signal that royal privilege stands above the law, that a prince can publicly denigrate the king's judges, accuse the legal system of corruption, and then simply have the sovereign quietly erase the financial consequences with a wave of a royal checkbook. The political backlash to even the mere suggestion of a royal bailout has been swift and merciless. High-ranking political figures, former Lord Chancellors, and legal authorities in the House of Lords have openly warned that any attempt by the palace to smooth over this financial mess would inflict severe, self-inflicted damage on the monarchy's public standing. The public patience for the Duke of Sussex's endless cycle of grievances and high-stakes courtroom dramas has completely worn thin. People are no longer looking at this as a tragic family rift. They are looking at it as an outrageous display of elite entitlement. A wealthy, privileged prince willingly chose to launch an aggressive, multi-year legal war, brought 97 completely unproven allegations to trial, lost every single count, publicly attacked the presiding judge when he didn't get his way, and now faces the exact financial consequences that any ordinary citizen would have to face. This entire saga cuts straight to the heart of the deeply ironic financial structure that Harry has built for himself since stepping back from royal duties. For years, the Duke of Sussex has funded his lavish California lifestyle, high-tech security details, and multi-million-dollar estate by trading almost exclusively on his royal status, airing private family grievances in best-selling memoirs, and signing massive media deals centered around his fight against the system. Yet here he is facing a legal bill so utterly immense that it threatens to completely consume the very fortune he built by weaponizing his royal identity. The money earned from publicly criticizing the institution is now being demanded by the very newspaper he sued, all because he couldn't control his emotional instincts when the verdict didn't go his way. As the crucial July costs hearing approaches, the tension inside Harry's legal team in London is reportedly at an all-time high. Drafting court submissions to mitigate the damage caused by a client who publicly trashed the judge presiding over his costs hearing is an absolute nightmare scenario for any barrister. Lawyers are attempting to carefully reframe the tone of Harry's furious post-trial statement without forcing him into a humiliating, formal retraction that would destroy his public pride. But judges in the High Court are trained to look at hard facts, cold conduct, and established legal precedents, not PR spin or celebrity maneuvering. Mr. Justice Nicklin holds all the cards, and he has already demonstrated in his exhaustive 436-page ruling that he has zero tolerance for vague assumptions, emotional theatrics, or high-profile grandstanding. If the judge decides to grant Associated Newspapers their demand for indemnity costs, lift the protective cost caps entirely, and order an immediate $13 million down payment, the dominoes will begin to fall with terrifying speed. The insurer will likely point to the whitewash comment to void the $19 million safety policy. Co-claimants will step back to protect their own financial interests, leaving Harry standing completely alone at the center of the legal arena. His commercial deals, which have already seen significant restructuring and public scrutiny over the past year, may not offer the immediate liquid cash required to satisfy an aggressive 14-day court deadline. The threat of charging orders over assets, public debt enforcement, and formal insolvency proceedings will cease to be theoretical talking points and become immediate, devastating realities. The ultimate tragedy of this entire ordeal is that Harry was repeatedly warned by legal advisors, senior courtiers, and well-meaning friends before he ever stepped foot inside the royal courts of justice. He was warned that civil litigation in the High Court is a brutal,